Okay, everyone, we are live, and my name is Marcio Katz. For those who don't know me, I'm the Chief Operating Officer for Get Global International. We are a data privacy consulting firm with operations in the US, Europe, and Brazil. So we are not a law firm. We actually are data privacy advisors. Most people think that data privacy is pretty much a legal issue, but it's pretty much more than that. And today we have the pleasure to be with Jenifer. How have you been, Jenifer?
Busy.
Busy. Okay. Okay. Well, today we are going to talk about the GDPR and the impact of the General Data Protection Regulation, the European General Data Protection Regulation in the US. Jenifer, could you please talk a little bit about yourself and how you got involved with data privacy?
Sure. I am born and raised Texas and have lived in New York City for 6 years and then North Carolina and now currently in Colorado. I started my career out as an IP litigator, mostly patents and trademark enforcement. So that was a fantastic experience. And it was sort of that was back when a data clause in a contract was maybe a line, 2 lines, we have data and we own it kind of thing. That was ages ago. And actually a breach of a family member's information several years ago got me interested, and I helped them claw their information back and secure it as much as they could. And so that's just sort of spurred this concern about what information we were given with regard to our own personal data. And then a friend that I was, my boss, who has now become a friend that I was working for, was expanding into Europe. And at that point, the directive was enforced or was in play. And that got me wondering as to why the United States didn't provide similar protections for their citizens and their data. So that in the 2012 election sort of kickstarted that curiosity, and I've chased it ever since.
Okay, very interesting. Today, we're not going to talk about the US data privacy regulation. It's an extremely interesting topic, but we've done that before. We have already talked about the bipartisan data privacy bill. We have talked about the new transatlantic agreement between the US and Europe. We have already talked about the 5 states data privacy laws: California, Colorado, Utah, Connecticut, and Virginia.
Right.
But today, we want to talk about the General Data Protection Regulation. The last episode, we had as a guest Puneet. He was born in India, but he's based in Belgium. And just like me, we both are Europeans data privacy advisors. I'm a lawyer. I'm a data privacy lawyer, but I'm a European data privacy lawyer and a Brazilian data privacy lawyer.
Right.
Therefore, I'm not licensed to practice law in the US. Actually, I'm a foreign legal consultant. So my specialty is pretty much the General Data Protection Regulation and the LGPD, the Brazilian LGPD. I'm going to try to explain here how the GDPR works. And then I want to hear from you, an American lawyer, how the US, the American organizations deal with the GDPR. Because I feel that many US organizations, they don't care so much about the GDPR, maybe because it's enforceable at one side. Technically, it's enforceable, but we haven't seen actually any American organization getting in trouble because the GDPR. But of course, there are the American companies that are based in Europe, and those ones, they have to deal with GDPR like the big techs, the big fishes, right? Well, the GDPR has a different standard, a different way of regulating data privacy compared to the way that the US regulates data privacy. I usually say that the US is more sectorial. So you have data privacy regulations for finance, health, children under 13, and so on. And the GDPR is a more comprehensive regulation, right? And it works pretty much like this. It says that you can't process personal data if you don't fit in one of the 6 different situations, which the GDPR calls a legal basis. So it means that you need to process personal data under at least one legal base. And there are 6 legal bases in the European GDPR. In the Brazilian LGPD, 10, but that's a different issue. Anyway, so that's the first thing that any data privacy advisor needs to deal with. We need to find out if your organization is processing. And when I mean process, I'm using this term because it's the term that it's stated by the GDPR.
Right.
So, and process means much more than just use or sell personal data, which is another big difference between the way that US and Europe regulates data privacy. Process means anything that you may do with the data, it will be considered processing personal data. So you need to follow one of the 6 different legal bases. Is that all? No, it isn't. Now we have another, one more issue to deal with, which are the principles. The principles of the GDPR are going to give you some boundaries. So you can now process personal data because you are going to do it under certain legal base, but that doesn't mean that you can do whatever you want.
Right.
So we are going to put some limits, some boundaries, and now you will have to process the personal data, taking into consideration those principles like minimization, for example, or you can't collect data that you're not going to use for that specific purpose, and so on. And then there is another group of responsibility that you need to deal with. It's not just the legal base, not just the principles, but the individuals now have some rights. Therefore, you need to be able to answer requests from some data subject. So that's another thing that a data privacy advisor will have to deal with. Is that all? No. Now we need to also work on the data protection, because so far we've been working on data privacy, the way we use, the way we process personal data, but we also need to protect the data, because you could either have a company or an organization that would be process the data lawfully, but the data is not protected. And vice versa. The data might be extremely protected, but it doesn't mean that the organization is processing the data properly. Right. So we also need to deal with it. So I usually say that there are 4 different categories of obligations that we need to deal with. I don't see any US regulation even close to this complication that I have just explained here. I think that in the US things are easier, and that's pretty much clear. The reason why in Europe it's an individual's right, in the US it's a consumer right. That's changing, especially in California, because it was a Consumer Privacy Act and it isn't anymore. Now we also need to talk about employees' data and so on. That said, how do the American organizations deal with the GDPR? I want to hear from you. I think that's one big question from our European data privacy advisors, because we do know how Europe deals with it. We know how some other countries that follows the GDPR standard deals with it. But how does an American company deal with the GDPR as such a different way of regulating data privacy?
I would, well, very carefully and very reluctantly. Initially, most companies will try to either limit the contact with the EU, especially if it's only tangential, it's not reoccurrent, it's not consistent. So certain companies, if they have very limited contact with Europe or the UK, will put up geofencing and restrict access to websites in the United States. So that's the first reaction, especially for medium to small size enterprises who don't have a lot of contact with Europe. Yeah. And it's basically a risk mitigation. We don't have to comply. We're not targeting EU or UK residents. So why would we make this effort?
Yeah, it makes sense. Okay.
Having said that, because of California's law, Colorado, Virginia, and Connecticut and Utah's and little things all over the place. First, those laws have sort of kicked off this need to be compliant with most of what the GDPR requires anyway. And I do not advise my companies, my clients, to go chasing every regulation. I think you should set a standard, a floor, best practices, and work from there. Especially if you are in health tech, ed tech, anything that has to do with sensitive data, such as health information, financial information. Now, I believe Colorado, and I haven't read the law enough times to memorize all of it, but California and Colorado, and I believe Connecticut have all determined that geo data, I believe, is a sensitive category. I need to double check that. I'm not 100% sure, but that information, along with, and I believe the CPRA has aligned that sensitive definition of sensitive data with that of GDPR. So those sensitive categories, companies that deal with that information already, if they have been working towards compliance, especially healthcare companies, they're already on a path to be GDPR compliant. They haven't hit all the standards yet, but they're close. Particularly, and this is my own opinion, but I had to work within the confines of HIPAA for quite a bit with a number of different clients. And HIPAA is one of the older laws that is on the books here in the United States that concerns information privacy, health data specifically, and it's PHI, protected health information. That, in my opinion, formed a framework that GDPR maybe wasn't built on, but took a page from. And if you take HIPAA's requirements, both from the security, the access, and the protective measures, as well as minimizing and limiting what you collect or how you manage that data, those basic principles, in my opinion, if you took HIPAA and expanded it to every single category of data, GDPR and HIPAA are very, very similar. I've had to crosswalk those two and work with an organization to implement both HIPAA controls as well as GDPR controls based on the articles of GDPR. And they work really well together. So one in the United States is very sectoral in what our laws do. You have GLBA, COPPA, HIPAA, FCRA. You have all this menagerie, this patchwork of laws that cover different parts of what data is out there. Whereas GDPR is this massive blanket that covers everything. So if a company in the US has worked to be COPPA compliant or HIPAA compliant or GLBA compliant, then they're already on their way to GDPR. So there's already controls in place, particularly from a security standpoint. What US companies struggle with is the acknowledgement of the scope of what is considered personal data or PII. Explaining to companies that a cookie or a pixel or geolocation data, or somebody's just their birth date in and of itself is PI or PII or personal data is sometimes it's a struggle because it's not innate to how the United States has operated before. And
yeah, I feel that it's as complicated as it is for a Brazilian lawyer trying to explain the Brazilian taxation for an American entrepreneur. I mean, it's just insane. I mean, it's not. It doesn't make part of their DNA. I mean, it's just it's something that it's not part of the way they do business. And I feel that. And I do agree with you. I think that most American entrepreneurs and CEOs, they are so into collecting personal data, personal information, because that's part of the business and that's just the way we do business. And we want to target the right consumer. And to do that, we need personal information.
yeah,
And the GDPR is just the opposite. I mean, it starts to regulate the way you are going to do things. You can still do things, but in a different way or different ways.
right.
And that's pretty much what we try to help them with. But I think that the beginning, it starts actually in understanding what personal data is, which is pretty much what you were saying.
Yeah.
As far as I understood, you pretty much said that if it's any small business, it's even better to avoid selling to Europe if you have to deal with the GDPR, right?
That's a discussion. That is a choice the business has to make. It depends on their appetite for the risk, their budget for compliance, all those factors. Okay. If they're doing business in California and they have a few customers, or they're not targeting people, but let's say they have one customer outside of Brussels and one customer in the UK. If you're already working towards CPRA compliance, then why not double check that against the framework and the articles of the GDPR and see what you hit, and put up a compliant cookie banner and work on that at the same time. If you're going to make the effort, if you can, excuse the analogy, but I was raised on a farm. If you can kill two birds with one stone, why wouldn't you? So that's
okay. That's the second part of your answer. I mean, it seems that from your perspective, U.S. data privacy regulation is becoming more and more a GDPR-like regulation. So why not?
Right.
Walk some miles ahead and comply with the GDPR, because once you do that, probably it's going to be much easier to comply with this CPRA and all the other the US data privacy regulation. Is that right?
Yes. GDPR has additional requirements, and I think that especially the regulators in Europe are more aggressive. The California AG just, I believe it was yesterday, the news came out that they just had their first enforcement decision against Aura, right? So
yeah, and I think that 3 weeks ago they published a 60-page regulation.
Yes.
on the CPRA.
That was fun reading, yeah.
And I think it was like 2 days before the 4th of July. So I'm pretty much sure that most data privacy advisors, they had a not so interesting holiday, because most of them were studying this new regulation. Yeah. Let me ask you something else. How does an American lawyer works with a foreign legislation? What I'm asking is that, from my perspective, when we talk about one specific law, it makes part of a legal system, right? And the GDPR is an European. It's not a law. Technically, it's not a law. It's a regulation,
right.
and there is a difference in the European legal system. But how does it work? I mean, because I feel that we are pretty much talking about civil law because it's Europe, and the US is common law. How do you guys deal with it?
As far as determining, when you say how do we deal with application of a European law, well, if you're doing business in Europe, there's more than just the GDPR to deal with. You have different taxation requirements, you have different employment requirements, you have different benefit requirements, and then on top of that, you are dealing with a very dense regime of, you know, governance over what information you can collect, as well as what information you and how you can contact people. Talking about PECR from the UK, the e-privacy directive, layered on top of, you know, GDPR. Then you have every member state that has their own preferences. I would say, I wouldn't call them their own regulations, but, you know, the way that they are enforced, what court decisions are made, and what that does to the business environment as far as how a United States company deals with that. And you'll hire really good local counsel. That's one place to start. And as far as being a United States lawyer dealing with that, you lean heavily on local counsel, but then you also, I analogize how the EU is put together to how the United States is put together. Every state has their own legal framework with regard to every single aspect of life. And so does the EU and every member state. So I think U.S. attorneys, when they are dealing with national companies that do, you know, international, but also interstate business, where their business crosses state boundaries, you have to comply with different state requirements. So dealing with that in the EU and the UK, well, what used to include the UK, it's, you know, it's similar. It's just the EU. The EU and UK regulations, as well as their laws, are, I believe, a little bit more prolific. That doesn't mean they're less efficient. It just, there's a lot more of them, I think.
I see. The reason why I'm asking that is that I do know that American lawyers are not allowed to give legal opinion on a foreign lawyer because they are not licensed as European lawyers.
Sure.
But at the end of the day, data privacy is not just a legal issue. So I feel that U.S. lawyers, data privacy U.S. lawyers, they work more as data privacy advisors, which means not actually legal interpretation, but more on telling the clients what they should do to comply with the law. And what's the difference? This is just advice on the things that you should do, and not in the interpretation of the law, which makes a little bit different. It's slightly different, but one thing is, you got to do this, this, and this, and this, and this, and this to comply with this law. The other thing is, no, what you are doing will affect this law because of this, 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 and this. But of course, I don't want to even get in trouble here. But of course, there are American lawyers that they do give legal advice on European law, and it happens. I mean, but it shouldn't. But it's okay.
Well, you have an American client asking you if a European law is applicable.
Oh, yes.
That is.
But it.
Yeah.
But it's the same thing that a European company asking a European lawyer about some American law. The American Bar Association wouldn't agree with that because he's not licensed. I mean, the European. So I just feel that data privacy is becoming something global, which I think it's very good. Get Global has its name as Get Global because data privacy nowadays is global. And that's the way I see it, and that's the way it should be. I'm just bringing this question because I heard from an European lawyer that these things happen, and I do understand where he comes from, but I think data privacy at the end of the day is a kind of regulation that everybody understands if
Well,
you definitely study the topic.
I think it's affecting more than just the legal compliance requirements of companies. I think because my background, part of this, I became educated as to privacy through colleagues and friends who all came from the security world. So I approach my first question to a client is not, what's your privacy framework? It's what security framework do you use, and what
Perfect.
yeah, that's because they're, at least I have, been raised, if you want to say, and learned my way through privacy with the adage that you can't have privacy if there's not security. And certainly the consequences of breaches, I mean, we're all very aware of what that can mean for not only just us as individuals, but also corporations, not just from a regulatory perspective, but from a financial and continuity perspective. So when it comes to compliance with privacy for a company that wants to do or is doing business internationally, there's an operational advantage, and I think there's a brand value advantage to getting these things in place. And you have several agencies in the United States in the past 3 years, I believe 3 years ago, starting with the SEC and the rules that they started to talk about implementing and requiring. And then you've had the FTC talk very recently about enforcing and being more aggressive when it comes to children's data under COPPA, and rewriting COPPA even, which I don't think is a bad thing. I think my father is also an attorney, and he has always told me that the law, and he's right, the law is, I would say, 20 years behind the technology. So we
Definitely.
and so GDPR was great. I was thrilled to learn about it, and I dug into it quite a bit. But it's, and as far as human rights, I believe when Schrems 2 came out, there was this great webinar that IAPP did. And one of the things I took away from it that has stuck with me is that in Europe, privacy to your own information is seen as a fundamental right. It is a right, like, your ability to speak out or study or be who you want to be. Whereas in the United States, it's more of a commercial. It's a commercial right. It's more of a
consumer right.
Yeah. And I mean, certain states, I believe California. There's a few others. I want to say Oregon and maybe even Kansas. In the state constitution, there's a distinct right to privacy written into the state constitution. So, I think the U.S. is struggling with that a little bit. And I also think that our culture here needs to change, and we need to educate people about what is done with their information. We, as a country, didn't go through what Europe did with World War II, and I don't think we're as sensitive to it.
I do agree with you, because one thing that doesn't make sense for me is the U.S. is a country about freedom and civil rights.
Yep.
And one of the most important civil rights that you can have is privacy.
Yep.
That's why your own home is protected. So how come the country doesn't care about data privacy if we are living in a world where everything is online? So it's just something that doesn't make sense to me. But on the other hand, we do know that enterprise and freedom of enterprise is extremely important
right.
to the US. So,
it's and I think it is starting to change, and I think I don't know if you remember, if you watched when Facebook, Twitter, and Google, the executives, the CEOs of those companies were brought before Congress. I was horrified because the Senate, they had no concept. And I'm going to use a very pedantic phrase here, you know, bless their heart, but they had no real concept or context for what anyway. And then you got to some House members who were much more educated or much more granularly aware of what these big companies do. And they're basically, you know, data companies. They collect, store, process, and manipulate data, and us along with it. So that's, yes, I think the culture is slowly starting to change. I think as like my generation, Gen X, starts, like, we dig in, and there's a number of us, and this is not okay. And this is, you know, my clients, the companies that I advise, you know, one of the best things I've found to do as far as changing the culture within a company is to talk to the people who actually deal with the data. And when you explain and you put into context what this means for not just the company, but the people affected, it clicks. And it's not that people are more callous or less concerned in the US. They just never really have paid attention to the fact that this is happening.
Yeah, I agree with you 100%. Well, we were talking about the American lawyer role dealing with the GDPR. But as I said before, the data privacy is not all about legal stuff, right?
Yeah.
So I feel that there are so many other things that we can do to help a company comply with data privacy regulation that I would like to hear from you. I would like to hear your opinion on how people who are not lawyers, and they don't tend to be a lawyer, can become a data privacy advisor. What would be their role? What they would do if they are not lawyers? What would they do? Because I do know what they could do, but we need you are the guest, so I want to hear from you. What could they work with here?
Well, forming the changing the culture of their organization, educating the organization. You can be educators, you can be internal auditors, have a lot to do with holding a company accountable for
compliance.
And but then there's also, you know, setting the policies and messaging within the company. And then you have your marketing team. And if I worked with a really great marketing team a couple of times where they're kind of caught because they need to get the information out. They need to find out who's watching what. And there's a whole debate about how effective and realistically how valuable these analytics are. But there's you know, people in marketing, I think, are aware of, and even more so keenly aware because of the issues with cookies and tags and all of that, and behavioral advertising. So they want to do the right thing. And if you can support that and you can educate them, and for me, privacy, circling back to the security thing, is more of an operational thing. It's more of because you not only do you have to do privacy by design in how you collect and manage or collect and store, but then you have, and this is one area in the US where I think the laws are starting or will start to bite, is what is the retention of that data? Because you can't hold it for 999 years. You need to have something.
And not all sort of data. I mean, it needs to make sense. I mean, why are you collecting that data, for example, if you are not going to use for one specific purpose, right?
Right.
Okay. So, the reason why I'm asking that is that I feel that in many other countries, you see professionals that might become a data privacy advisors, and they have different backgrounds. They come from the information security, they come from compliance, they come from I don't know, even IT guys that want to be more close to data privacy or whatever, and of course lawyers. I think that it's not so clear for American companies what a data privacy advisor does. We actually work with the assessment, and you don't need to be a lawyer to understand how you collect the data, what data you collect, where you store, who you share the data with, and so on. So you could work on the assessment. You could also work in trying to understand the way the company process personal data will affect the company complying with the law. I mean, what you do here is not okay. This way, you might get in trouble here. Of course, you're not going to give a legal opinion, but you can at least understand the scenario, and you are able to advise what you should change in order to comply with the law. It could either be change the process, the way you do something. It could be like the culture, as you said, and I think it's one of the most important and the most difficult thing to do, because you need to explain to the whole company that they should do business differently the way they have been doing the past years. Or you could either help them implementing a data privacy software. Sometimes we are talking about a big retail chain that you definitely need a data privacy software, because it would be just impossible to comply with the law. It could be
or even
big ID, One Trust, or whatever. And of course, there is the legal aspect of it, and that we would leave with the lawyers. It could be an American lawyer or European lawyer. For me, it doesn't matter. But also there is some discussion on this matter here. So I think that it's something that the U.S. market will start to understand the opportunities if they understand what the problem is about. And we began this conversation by saying, I don't feel that the American companies understand the problem itself. I mean, they struggle in understand what data privacy is, much more all the consequences of dealing with data privacy.
I have found that companies that do a lot of analytics and a lot of analysis of data understand the consequences much more readily than other companies that just use it tangentially, as far as like email campaigns or outreach, or it's not necessarily the analysis of the data that's done internally. They just use it for marketing and stuff like that. But if the company is built on the premise of this data provides the backbone of what we...
If it's part of their card business, they do understand the issue.
They understand the value of retention periods and data, and what is dark data, can we identify our data, do we know where it is and where it's coming from? Those things are all important, because you can't do good analysis with bad data. And if you're throwing junk, garbage in, garbage out. So that's I think those companies. And then you have a lot of B2B companies that are growing and are looking to grow either in to Asia or to Europe or to the UK, and they have to transfer data across, right? There's those forward transfer concerns, and I think when a company has to start dealing with those concerns, that were the SECs and the abundance of paperwork that we now have to do in every single addendum. It's those things wake a company up, because those are consequential. And there are companies in Europe and regulators in Europe. My favorite is the one in the Netherlands, and they, if you don't have your house in order, then you can't do business here, and that's consequential.
Yeah. I think that I do feel that there are so much ground to be covered and so many things to come in a short period of time. I feel differently than many American data privacy advisors that at certain point the US will have a more comprehensive data privacy regulation. And I do feel that, and I do think that it might happen in the future for different reasons.
Right.
I feel that American companies are already struggling in doing business internationally, and that's a big, big issue economically, politically, and so on, wise. And I do feel, as you said, that Americans are becoming more aware of the importance of data privacy. So at a certain point, I'm pretty much sure that the US will pass a data protection bill.
Right.
And I don't know what bill it's going to be, if it's going to be a more GDPR-like regulation or something totally different. But that's just the way I see it. I want to hear from you. What do you think about it?
I think it'll be pressure from companies that are having to deal with 12 different states' regulations. And the fact that California changes theirs every 18 months. So there's going to be some there's aggressive attorney generals here in the United States, and there are some that are active in this space even without a privacy regulation. The Attorney General in New Mexico is very keenly aware and educated in this space. And then you have our Colorado AG, Phil, and he is he's brilliant. But on top of that, this is part of what he has supported here in the state of Colorado for a long time, was not just the privacy law, but just the awareness of what companies do with the information, and are consumers aware of what is done with their information. And then, but yeah, I think the dam will break. I think it'll be another year or two, just because I think there's a number of laws. As I think when Texas passes their privacy law, that's when the dam will break, because you have
New York or Texas for me is like
those are watermarks.
It's the last drop to full the glass. I mean, it should. So we'll see what's going to happen. Many people don't understand who we are. I mean, Get Global International, and why we have this podcast here. But we are an international data privacy company. We've worked in more than 200 projects in Europe and more than 300 projects in Brazil. As I said before, I'm a European and Brazilian lawyer. I have helped with the Brazilian government in drafting the LGPG. And I have just immigrated to the US. So I got my green card on extraordinary abilities because of my 20-year career as data privacy professional. But it's been a challenge because the US is big as it is, as it's important as it is. But I feel that the US is like taking baby steps toward data privacy, and sometimes we want to see things happen, and it just doesn't happen the way we would like to. But at a certain point, I feel that things are going to change. Anyway, it was a great conversation. Thank you so much for being here with us, Jenifer. Yeah, thank you. It was really nice. And for those who have been with us here live, we are going also to be on Spotify in a couple of hours. So thank you so much, everyone, for being with us, and see you later. Bye-bye.
Bye, guys.
Thank you.